This video series is a walkthrough of a book written by Dr. Marc Howard in 2017 titled Unusually Cruel, wherein Dr. Howard describes the state of incarceration in the United States and compares it to three other democracies, France, Germany, and the United Kingdom. I've included a link in the description of Marc Howard's website. If you like this video, you can follow the link to purchase his book. Although Unusually Cruel is a comparative policy book, in this series, I will largely focus my attention on the United States. The book is organized into 6 categories that Howard calls the criminal justice life cycle: plea bargaining, sentencing, prison conditions, rehabilitation, parole, and societal reentry. Howard argues that in all 6 categories, the United States is exceptionally punitive compared to other democracies. His website states, "Although Americans are no more likely than members of other societies to be the victims of crimes, the United States maintains an incarceration rate that is 7 times higher than other democracies." Indeed, according to the International Center for Prison Studies, while the United States represents roughly 4.4% of the world's population, it houses about 22% of the world's prisoners. At any given time, 2.3 million individuals are locked up in the United States, of which about 700,000 are in jails, and another 1.6 million are in prisons. This pie chart created by the Prison Policy Initiative represents data from 2019. Before we continue, it might help to quickly distinguish between jail and prison. Generally speaking, jail is an institution under the jurisdiction of local government for the confinement of people awaiting trial or for those convicted of minor crimes. Prison is an institution, usually under state jurisdiction, for the confinement of people convicted of a serious crime. Additionally, there are 5 million people who are on probation or parole. This means there are roughly 7 million people under some form of carceral supervision in the United States. Of the people released from jail or prison, 20 million of them have a felony criminal record. Some 50 to 70 million people have some kind of criminal record in the United States, which include misdemeanors. People generally understand that felony criminal records place a significant burden on an individual's opportunity and likelihood of successful societal reentry, but some misdemeanors can show up on job searches and housing applications, among other things. The U.S. incarceration rate never used to be so high. Beginning in the late 1970s, the United States began to drastically increase its imprisoned population. This is largely due to sentencing reform. Although the crime rate has steadily declined since the 1990s, the incarceration rate has since increased exponentially. Separating the statistics by gender, race, and ethnicity, it is clear that men, and in particular black men, have been most affected by the increased incarceration rates and punitiveness. Indeed, according to the Bureau of Justice Statistics, 1 out of every 3 black men born in 2001 will face some form of imprisonment. For white men, that figure is 1 out of every 17. This brings us to the first phase of the criminal justice life cycle, plea bargaining. In theory, plea bargaining represents a mutually agreeable arrangement between 2 opposing sides, the prosecution and defense, in criminal cases. It usually involves the defendant pleading guilty to a lesser offense or to only one or some of the counts of a multi-count indictment in return for a lighter sentence than would occur with the more serious charge. Both sides can be spared the time and expense of a trial when they are in agreement as to the facts committed and the appropriate punishment. Plea bargaining is based on the assumption that the defendant has knowingly waived his or her right to a trial, that the waiver was entirely voluntary, i.e., not made under threats or even subtle coercion, and that there is an actual factual basis to the charges and terms of the plea bargain agreement. Plea bargaining has a long-standing, revered history in the United States, dating back to the mid-19th century. Long after plea bargaining had become an established practice, the Supreme Court addressed the issue in several cases, all of which increasingly endorsed and advocated for the use of plea bargaining. In the United States v. Jackson, the court worried about accepting plea bargains as a means of avoiding the death penalty. The problem was not so much coercion, but of encouragement for defendants facing capital charges to accept a plea bargain. In Brady v. the United States, the court specified its previous opinion that the plea must be entirely voluntary and, in addition, such arrangements must be beneficial to both the defendant and prosecutor. In Santabello v. New York, the court fully endorsed plea bargaining, stating that it is an essential component of the administration of justice and should be encouraged when properly administered. A few years later, in Bordenkircher v. Hayes, the court further facilitated the task for prosecutors to pressure defendants into accepting plea bargains. The narrow majority affirmed a life sentence for a Kentucky man with 2 prior felony convictions who rejected a 5-year plea offer for his third crime of forging a check for $88.30 under Kentucky's Habitual Crime Act. The court answered in the negative to the following question: does the 14th Amendment's Due Process Clause prohibit state prosecutors from carrying out a threat made during plea negotiations to reindict the accused on more serious charges if he does not plead guilty to the offense with which he was originally charged? Despite the Constitution's emphasis on jury trials, such as Article 3, Section 2, and the 6th Amendment, the United States has a long history of using plea bargaining and is clearly supported by the Supreme Court. The 2 most common forms of plea bargaining in the United States are charge bargaining and sentence bargaining. Charge bargaining is when the defendant and prosecutor negotiate which charges will be brought against the defendant. Charge bargaining is used by prosecutors to get the defendant to plead guilty to a lesser charge in order to avoid a potentially lengthy, costly, and harder to convict higher charge. Sentence bargaining is when the defendant and prosecutor negotiate a lower sentencing length in exchange for the admission of guilt for a charged crime at the guarantee the defendant will receive a lesser sentence than he would receive if found guilty of the crime at trial. In theory, plea bargaining does have some advantages. Plea bargaining alleviates heavy caseloads for judges and prosecutors and satisfies 3 goals for the prosecutor. 1, gaining convictions without lengthy and costly trials. 2, avoiding the potentiality of losing the trial, which could prove politically costly for elected prosecutors. And 3, reaching agreements that satisfy their objective of punishing crime. For the defense, guilty defendants are given the opportunity to accept a lesser charge or lesser sentence than would be given if found guilty at trial. For the defendant's lawyer, it depends on how the lawyer is being paid. If the lawyer is receiving a flat fee or a regular salary, the lawyer has little incentive to increase her already heavy caseload, and it is in her interest to resolve cases as quickly as possible. This becomes problematic when determining whose best interest, the defendant's or the lawyer's, is being served. However, it has been argued that plea bargaining in practice is far from theory. Some scholars assert that the core assumption behind plea bargaining, that the decision made by the defendant is genuinely voluntary, is not met in that the plea bargaining process is largely coercive in nature. Plea bargaining can also lead to wrongful convictions based on false guilty pleas. According to the National Registry of Exonerations, over 300 of the 1,900 people who have been exonerated since 1989 had pled guilty. Indeed, of the 157 exonerations in 2015, 68 had pled guilty. Prosecutors often bluff defense attorneys and defendants into pleading guilty to lesser charges, even when they may have been acquitted based on a lack of evidence or actual innocence. Some claim that this is out of fear. Similarly, Stefanos Bibas, a judge on the United States Court of Appeals for the Third Circuit, has also asserted that the classical trial model diverges from plea bargaining reality in 2 ways. First, there are many structural impediments that distort bargaining in various cases. Poor lawyering, agency cost, and lawyers' self-interests are prime examples, as are bail rules and pretrial detention. The structural skewing of bargains has grown in the last 2 decades with the proliferation of mandatory sentences and sentencing guidelines. Since most of the literature predates the sentencing guidelines revolution and the spread of mandatory minima, the area is ripe for a fresh look. Second, the shadow of trial model assumes that the actors are fundamentally rational. Recent scholarship on negotiation in behavioral law and economics, however, undercuts this strong assumption of rationality. Instead, overconfidence, self-serving biases, framing, denial mechanisms, anchoring, discount rates, and risk preferences all skew bargains. Defendants who are held in pretrial detention for lengthy periods, unable to post bail, face incredible pressure to agree to any plea bargain the prosecutor offers in order to regain their liberty. These pressures include, but are not limited to, the ability to keep a job or to maintain custody of their children. For example, in cases where the defendant has already served a lengthy amount of time in pretrial detention, he may be offered a time-served plea bargain. Even if the defendant is innocent, he may accept the deal and plead guilty rather than await trial. Moreover, inadequate defense counsel may pressure their client to accept the bad deal. Finally, as some legal experts have pointed out, the typical plea bargaining process can hardly be described as bargaining. Consider, for instance, Milton Human's description of practices in Connecticut State Court. Typically, a line forms outside the prosecutor's office the morning before the court is convened. Defense attorneys shuffle into the prosecutor's office and in a matter of 2 or 3 minutes dispose of one or many cases set down for that day. Generally, only a few words have to be exchanged before agreement is reached. The defense attorney mutters something about the defendant, the prosecutor reads the police report, and concurrence on what to do generally, but not always, emerges. As Malcolm Feely memorably put it, plea bargaining in this mode resembles less a Middle Eastern bazaar than shopping in a supermarket. Arriving at an exchange in this context is not an explicit negotiation and bargaining process. To the extent that there is any negotiation at all, it is debate over the nature of the case and hinges largely on establishing the relevant facts, which flow from various interpretations of the police report and only occasionally involve independent investigation by a defense. In a supermarket, customers may complain about prices, but rarely bargain to get them reduced. One tactic, which is common practice among prosecutors, is overcharging. Overcharging refers to a prosecutorial practice of filing or threatening to file additional charges as a means to pressure the defendant to accept a plea. Overcharging has become more effective by the imposition of mandatory minimum sentences. Overall, the reality of the plea bargaining system in the United States is much different than in theory. Prosecutors in the United States wield enormous power to pressure defendants into accepting a plea deal. Indeed, approximately 95% of criminal cases in the United States are settled by plea bargains. Perhaps the most important feature that helps explain the nature of plea bargaining in the United States is its adversarial legal system. An adversarial system, like those used in the US and the UK, consists of two competing parties arguing their cases to an impartial decision maker, either a judge or jury or both. If the defendant in an adversarial system admits guilt, the case is closed without a trial and the defendant is sentenced. In contrast to adversarial systems, there are inquisitorial systems, which are used in many less punitive European countries. An inquisitorial system consists of a judge who plays a more active role in searching for the truth, whereas the two competing parties play a more passive role. If the defendant admits guilt, the need for a trial is not eliminated, thus preventing the type of plea bargaining used in the United States. This concludes our first episode of a series on incarceration in the United States. Tune in next time when we examine the second phase of the criminal justice lifecycle, sentencing. If you enjoyed this video, please subscribe to the channel, and thanks for watching.